Thank you so much. Good evening, everyone. This is indeed a very great opportunity that we are interacting on the subject of investments by our colleagues, brothers and sisters in the diaspora. I'll try as much as possible to be practical as the moderator has suggested while referring to the presentation that is being beamed. So to begin with, let's all agree that the laws that govern land in Malawi, starting with the Constitution. On slide number 2, we are saying that the land and all the territories of Malawi are vested in the Republic. And this is also buttressed by the provision in the Land Act, Section 8, which also says that all land is vested in perpetuity in the Republic. What this means is that anybody wanting to access any type of land for investment anywhere in Malawi is supposed to comply with the provisions in the land-related laws. Moving on to access of customary lands by Malawians in the diaspora. So the question is, can Malawians in the diaspora access customary land? The answer is yes. Anybody who is a Malawian can acquire customary land. And the Section 21 of the Land Act empowers the minister to have mandate of administering customary land. Now, looking at that process, which is being beamed, we are saying that an individual applies for a lease to the minister, and the title is granted by the minister. And once the title is granted, it is registered in the land registry, and followed with that, there are terms and conditions that are supposed to be agreed by the lessee and the lessor between the one investing on the piece of land and government. Moving on to the next slide, the question again is, can Malawians in diaspora access customary estate? Registered customary land is called customary estate according to the Customary Land Act. How can Malawians in the diaspora access customary estate? Once customary estate has been registered, it becomes private land. So anybody wanting to access customary estate, which is registered private land, can apply for a lease. The application now, in this case, will be submitted to the owner of that land. And the process is that the lease is going to be granted by the Customary Land Committee and the Traditional Authority, the TAs. Once the lease is granted, then it is registered at the land registry. And then the terms of the lease are agreed, just like between government and the developer when the lease is granted directly by the minister responsible for land matters. So the investor or any developer will have to agree with the private landowner on the terms. Now, because the customary estate is owned in perpetuity, anybody wanting to lease customary estate can be granted a longer term, 50 years, 99 years, depending on the conditions that the two parties agree. Moving on to the next slide, access of public land by Malawians in the diaspora. I just want to emphasize that Section 16 of the Land Act, Section 16 of the Land Act simply says that the use and occupation of all government land other than land reserved for the use and occupation of the president shall be controlled by the minister. Now, how can members in the diaspora access public land? Section 9A of the Amended Land Act. It is a right to every Malawian to access public land. But this is subject to availability of land and a person's means. Again, that land can be accessed for shelter and livelihood. Again, government shall ensure that there is no concentration of land in a few individuals to the disadvantage of other deserving persons. That provision simply is trying to ensure that all Malawians have access to the scarce means of livelihood. Next slide talks about the minister prescribing land ceilings. While the Land Act has made provisions for the minister to prescribe land ceilings, the Act goes on to say that the ceilings can only be prescribed subject to availability of land, utilization of land, and capacity to develop the land. So the land regulations have not prescribed the amount of land that an individual can access or number of plots that an individual can access. But this will be considered as and when applications are submitted by individuals who want to develop. But as long as an individual has the capacity to develop the land, and the land that he or she has already accessed is adequately utilized, then will be allowed to access more land. Let's move on to land that is designated purely for investments. All land identified for investments shall be managed by Malawi Investment and Trade Center. So the procedure is that land is going to be identified, published in the Gazette, and allocated to MITC, who also create subleases to be granted to investors. The land sizes to be allocated will be determined by the minister, taking into account the type of development, the scale of the development, or the use that is being proposed, whether it's agriculture, whether it's urban developments, all that will be taken into account. But there are also these additional provisions to say that if land is not developed within the prescribed 2 years, then the plots may be withdrawn. And where there is under development, the plots shall be subdivided and part of it reallocated to other potential developers. That's according to provisions and for land for investments. Again, Section 9B of the Land Act has restrictions in terms of sale of vacant land. So any sale of vacant land, whether it's a leasehold or freehold, is prohibited. Whereas the Customary Land Act, under Section 28, subsection 1, it prohibits sale of customary estate. Let's move on to the next slide that talks about access to land by non-citizens. Land shall not be granted or sold to a person who is not a citizen of Malawi. And any existing grants in favor of persons who are not citizens of Malawi shall be valid until expiry. Again, any existing leases shall not be renewed if land is not developed, of course, subject to this other provision which says an existing lease in favor of a person who is not a citizen of Malawi shall be valid until Okay, let's move on. We are saying that any existing lease in favor of a person who is not a citizen of Malawi may, upon expiry, only be renewed if the land is developed and used as a residential home or commercial or charitable purposes. I want to provide more details on the concept of a customary estate, because this is an area, again, that is attracting so many interests. Next slide. Section 20 of the Customary Land Act. A customary estate shall be allocated by a land committee to an indigenous Malawian or family of indigenous Malawians or a group of 2 or more indigenous Malawians, whether associated together under any law or not. And a land committee shall not allocate a customary estate to a partnership or a corporate body whose members or shareholders are
Hello, Commissioner Lucas Tembo? Are you there?
Looks like he got disconnected.
Got disconnected? Okay. Probably to his internet. Let's just wait a minute. Hello, Commissioner Tembo? Sorry, Commissioner Lucas? Commissioner Lucas? Are you there? Are you there now?
He's back, I think.
He's back now, yeah?
Yes, I'm back.
Thank you very much. Thank you very much, Commissioner.
Let me proceed.
Carry on.
Yeah. Okay. So the next slide, we are talking about the options of leasing a customary estate. In considering to lease or sublease a customary estate, the following conditions will have to be taken into account. So if a customary estate has, somebody wants to lease a customary estate, there should be reasons for the proposed lease, terms of the lease, including the duration, agreement on what will happen after the lease expires, confirmation of all the dependents or members of the family unit of the one holding the land, and the evidence that all dependents of the lessor who are above 18 years have agreed to the transaction. This is very important because it's just a way of saying, as much as someone has got a customary estate, can lease it out to any developer or any investor. However, that should not be at the expense or at the disadvantage of family members. Let's move on to the next slide. In the next slide, we are looking at investment opportunities for the diaspora community in urban areas. I will narrow into case of Lilongwe City. So the next slide, we are talking about Area 27 within Lilongwe City. This is a piece of land from Kanengo going towards the Young Luke Hospital or Malawi Institute of Management. There's that land on the right-hand side. That piece of land, we have designated a number of plots which our colleagues in the diaspora can access. However, we are in the process of paying compensation so that the people who are using that land can stop using it, and then the land can become available for development. So already within that master plan for that area, there are plots for multi-story apartments, which we think with the coming in of the sectional titles bill, that provision can be applied in that area. We also have got plots for townhouses, about 180 plots. There are plots for single-story dwelling houses. And coming on to the next slide, there are also plots that have been reserved for high-rise commercial or office buildings, plots that are dedicated for hotels, lodges, plots that have been reserved for heavy and light industries within the same locality, Area 27. But at the same time, Area 55, you might have heard about the Maguero Industrial Park. It's land in excess of 467 hectares. The land will be planned and developed by a private developer. Part of the land, there will be industrial shells, and these will be available for both local and foreign investors. But at the same time, within Lilongwe City, we have parcels of land owned by private entities. Examples are, there's a piece of land in Area 45, which used to be called Katete Farm, and another piece of land which used to be called Jewa Farm. All these pieces of land, the landowners are currently looking for investors. There are various types of plots, residential plots, commercial plots, and even industrial plots. The owners are ready to grant subleases for all types of plots to investors, including Malawians who are in the diaspora. Let me just talk about a little bit about the granting of development permission. The next slide. On that slide, I'm saying that the Physical Planning Act has made provision to say that if one submits an application for permission or for the grant of development permit, that permission has to be granted within a period of 60 days. So that's a very important amendment to the process of granting permission, such that if he just excuse me, let me just close the door. If an application has not been consented to by the relevant planning authority, there is a provision in the Act to say that the developer is at liberty to commence development. This provision was made to ensure that there are no undue delays in the granting of permission to those that want to start construction. Let's move on to the next slide, which talks about types of permissions that may be granted by planning authorities. as the law stands, if one wants to construct utilities like sewer lines, roads, communication cables, one is supposed to obtain planning permission. You want to put up an advertisement, you want to subdivide land or amalgamate land or change use of land or building, all that is supposed to be approved by the relevant planning authorities. Let's move on to, I have added some information regarding registration of land in Lilongwe West. This is slide simply showing the Magwero Industrial Park. For those that are conversant with Lilongwe, this is a place closer to the airport, but specifically on the left-hand side, as you are coming from town. That's where the industrial park is going to be located. Next slide. Now, let's move on to the registration of land in Lilongwe West. Okay. Okay, so I will talk about some issues related to registration of private land in Lilongwe West because there was a question. So this presentation that is being beamed does not have these two slides. To start with, I just want to give a background. For those that are very conversant with Lilongwe, there is an area which we call Lilongwe West. Lilongwe West land was registered using the Customary Land Development Act and the Local Land Board Act. These pieces of registration were repealed in 2016. This land was registered as private land. The moment that land was registered, its status changed from customary to private. However, the majority, including the owners, misinterpreted the ownership of this land to think that they can do whatever they want on that piece of land. And because of that, and because of the high levels of urbanization, so many people have been trekking to Njewa area, Airwing area, Likuni, NRC, including Bunda side, to buy land. So this is what had happened. This land, after it had been registered, it was registered in the names of the family heads, who we were calling the family representatives.